This has been an interesting, at times thought-provoking, high-minded debate where we've heard some interesting comments on the principles of criminal law. But I have to say that from where I have been sitting, there has also been, to some extent, a degree of unreality in the debate. We've heard from a number of speakers now, for example, that there's an absolute right to be present at one's trial as an accused in this country. An absolute right. Well, I can tell this House that's not the case. I can tell this House that there's not much actually in criminal law that is absolute. And whilst the circumstances where an accused wouldn't be present at his or her own trial are, I accept, rare indeed, it shouldn't be elevated to a fundamental, absolute, never transgressed right. For example, there is a strain of cases in this country, in the High Court, often in multi-accused trials, Mr. Speaker, where in order not to hold the trial up, and also because the accused may be seen to be trifling with the case, perhaps he or she hasn't appeared for his case, the trial proceeds in his or her absence, the evidence is called, and he or she will be found guilty or not guilty at the end of that case, often with, or I should say really, with very significant penalties imposed. That's not true. David Parker says, no, if they want to be here. There is a strain of cases, and I accept it's exceptionally rare, but in this country that says that if the accused, that there are situations where accused and the trial can proceed without the accused. The other thing that we've heard, from the Honourable Leanne Dalziel, I think also from Kennedy Graham as well, actually this is entirely, or should be, about the victims. And I agree it should be about the victims. Leanne Dalziel said, well, the victim has a right to be heard. And I entirely agree with that, but I can tell that member there's not a defence counsel in this country in a case where it mattered that wouldn't want the victim or the complainant there in person. And really, you're only ever going to have it on application from the Crown or police that the victim would do it by AVL. So again, I say actually an air of unreality in some of the things being said. Of course, to pick up on some of the things Kennedy Graham's saying, he's saying, well, you know, this AVL and in relation to victims or complainants, as they're actually called at trial, it could have some real problems. Well, again, I say, and there are many, many cases in this country today, before we pass this law, where complainants in criminal cases give their evidence by CCTV, so in other rooms, by video link. They are not physically in the court. That happens, actually, I can say with confidence, every single working day in this country. So we aren't, in fact, dealing necessarily with absolutes here. Criminal law is often developed by experience and on a case-by-case basis. And my real criticism of the Labour Party's position is that it is, if I can put it this way, a bit simplistic. It's a blanket rule approach, where actually what National is saying, or what I should say, not saying, is that all substantive hearings will now be by AVL. We're not saying that at all. We're saying let the courts work through it, work through the range of, I think, quite strict criteria that we've put into this bill for them. And we're saying that for trial by, or where there is AVL for the accused, I think that the Minister put it more judiciously than me. He said there'd be legitimate caution by judges. I think, and I'm not trying to in any way fetter what judges do if they look back at this debate, I think it will be exceptionally rare, if at all, that accuseds will be giving evidence by AVL at their court case. But there you have it. We've left the door open. I think that's the right thing to do, and to leave it to the judges who may well have, and I think this bill adopts, a more sophisticated approach. Of course, it's been said, well, there's absolutely no mischief here that we're remedying. In fact, I can perceive of cases where it would be perhaps in the interests of justice that we do have accused give evidence by AVL. Very rare, but there will be, and there may be in this country, cases where accused are harming or of a real danger of harm to themselves and to others. Mr. Kennedy Graham laughs. In fact, that's not necessarily something that we should laugh at. It happens. There are cases like that, cases where they are not insane, where they have not met those legal tests, but where they are in court with really serious issues. And I'm not saying it's likely. It may never happen. But we are not closing the door in this case. The other things I'd just say very, very briefly in considering all of this. Remember that the definition for substantive hearing is very, very wide. So we are talking about, when we talk about substantive hearings, anything where evidence is called. They can be very minor matters. And in those cases, it may be absolutely right that the accused gives evidence by AVL in a minor bail matter where he just wants his or her address changed from 63B Grove Street to another address. And AVL may be the appropriate way to have the evidence heard in that matter. Secondly, remember this, and I've said it before, but I just want to reiterate and emphasise it. We've set the bar high in this legislation for a substantive hearing, for AVL to be considered and adopted. The courts are going to have to consider and turn their mind to clauses 5, 6 and 9 of this bill. 6 is effectively the most significant one, and there we see that they must take into account, I won't go through them all, but the ability to comprehend the proceedings by the defendant, to participate effectively in the conduct of his or her defence, to consult and instruct counsel privately, it goes on. All of those, I would suggest, certainly when we get to the business end of a trial by jury or a trial by judge alone, when someone's guilt or not guilt, as it may be, is on the line, judges will go through those very seriously. As I say, my personal view on that, as a former lawyer, is it would be a very rare case where AVL for the accused in a trial would be granted. As the Minister said, judges would have legitimate caution. That's their culture. That is the way they do things. So, Mr. Speaker, I think we aren't being simplistic. We're leaving this to judges to take a more sophisticated approach. I think there's been an air of unreality in this debate, and when we actually consider things in the cold light of day, this bill is a good thing. It will make courts more efficient. It will lead to better safety in courts, and I commend it to the House.
I call Jacinda Ardern.
Thank you, Mr. Speaker. I want to first begin by